This is a huge win for AI, exceedingly transformative, and was a fair use, quintessentially transformative. Spectacularly so. The most transformative many of us will see in our lifetimes. And this is from a guy who's seen a lot. This is no longer an AI case, it's just a piracy case. The AI part is over and done. Excellent news, everyone. Major win in an AI case. This dropped like the night before the last day of my vacation. So just got home, just got unpacked, and I'm going to go over it for you. People are talking about this and there's misinformation, so I'm going to be correcting all of that. This is a huge win for AI. Maybe not quite the win for Anthropic that they were wanting. But yes, this is Bartz v. Anthropic. You remember the one where the plaintiffs went in complete hysterics, and they were just completely embarrassing themselves in front of Judge William Alsup, who, if you remember, I've covered this before, he was the judge in Oracle v. Google, so he knows wherever he speaks when it comes to copyright and fair use. He even taught himself to program so he could learn the ins and outs of the case and what it all meant, so it's just great, and I think this is a really good decision. Even if it's not everything Anthropic would have wanted, it is absolutely what we're looking for in these AI cases. So we're going to start over here on page 6, and ordinarily I would say go with the blue page number at the top, not the black page number at the bottom, because that's page 6 of the actual PDF file. But in this case, they're all the same. Page 6 is page 6 is page 6. We'll start about the middle of the page. Each work selected for training any given LLM was copied in 4 main ways, and in fact, so many times that Anthropic admits it would be impractical even to estimate. They made so many copies. But as I pointed out, if at least one part of the chain is transformative, then the whole thing is fair use. So here he goes into it. First, each work selected was copied from the central library to create a working copy for the training set. Second, each work was cleaned to remove headers, footers, page numbers, things like that. Third, each cleaned copy was tokenized. The resulting tokenized copies were then copied repeatedly during training. By one account, this process involved the iterative trial and error discovery of contingent statistical relationships between each word fragment and all other word fragments, both within any work and across trillions of word fragments from other copied books, copied websites, and the like. Other steps in training are not at issue here. Fourth, each fully trained LLM itself retained compressed copies of the works it had trained upon, or so authors contend, and this order takes for granted. As we've covered before, that is not in any way how AI works, but we're talking about a summary judgment here. We haven't had any fact-finding in this case at all. So what's happening is Anthropic is moving for summary judgment, kick this out based on fair use. Since they're the defendants, and since none of the facts have been adjudicated yet, then you assume the facts in the light most favorable to the plaintiffs, and you say, okay, look, even if every single fact the plaintiff says is true, this still doesn't work, kick it out. And you'll see Alsup doing this throughout, that he's going to say, yeah, we're just going along with what they say for now. And he really seems to be doing it on points like this, where the LLM is retaining compressed little copies of it. It's kind of strange for him to do that on this point and not really emphasize it on others unless he's really doubtful that this is the case. So Alsup does not seem to buy this whole thing about it retains compressed copies, but that's what we go with because that's how you do a summary judgment. Now, if the plaintiffs were moving for a summary judgment, it will be the defense that he'd be giving deference to with all the facts, because that's just how you do it at this early point in things. However, that was as far as the training copies propagated toward the outside world. As a result, authors do not allege that any infringing copy of their works was or would ever be provided to users by the Claude service. Yes, Claude could help less capable writers create works as well written as authors and competing in the same categories, but Claude created no exact copy nor any substantial knockoff, nothing traceable to author's works. Such allegations are simply not part of plaintiff's amended complaint, nor in our record. So they're not even saying that Claude's outputs are infringing. They're not alleging that at all. So middle of page 8, Anthropic now moves for summary judgment on fair use only. To prevail, Anthropic must rely on undisputed facts and or factual inferences favoring the opposing side, as I just explained. Anthropic thus bears the burden of production and persuasion in this motion. And he goes ahead and gives away the ending on page 9. The use of books at issue to train Claude and its precursors was exceedingly transformative and was a fair use under Section 107 of the Copyright Act. Boom! That is the one that makes all of AI fair use. As soon as you go through that transformative step of training the AI, all the rest of it is fair use. None of it is infringing. Exceedingly transformative. As I've said many times, if AI training isn't transformative, nothing is. And saying that it is would effectively destroy fair use, and Alsup knows it. So we'll go over the 4 factors of fair use starting at the bottom of page 11 here, starting with number 1, the purpose and character of the use. All agree that one use at issue was training LLMs to receive text inputs and return text outputs. More specifically, Anthropic used copies of authors' copyrighted works to iteratively map statistical relationships between every text fragment and every sequence of text fragments so that a completed LLM could receive new text inputs and return new text outputs as if it were a human reading prompts and writing responses. The purpose and character of using works to train LLMs was transformative, spectacularly so. And over on page 13, and I said this was embarrassing for them to cite Thomson Reuters, but the judge there twice emphasized that while discussing purpose and character of the use, that what was trained was not generative AI. Rather, what was trained using a proprietary system for finding court opinions in response to a given legal topic was a competing AI tool for finding court opinions in response to a given legal topic. I wonder if he intentionally stacked them like that on those 2 different lines. Great way to make the point. That was not transformative. A better analog to our facts would be an AI tool trained using court opinions, briefs, law review articles, and the like to receive legal prompts and respond with fresh legal writing. And on facts much like those, a different court case came out the other way. White v. West Publishing. We haven't talked about that, so I'll link to it below if you want to read it. It found fair use. So quit citing Thomson Reuters. It's just gonna make you look dumb. And to everyone else out there, if you see them citing Thomson Reuters, throw White v. West Publishing back at them. In short, the purpose and character of using copyrighted works to train LLMs to generate new text was quintessentially transformative. Is he being clear enough for you here? He's not mincing words, is he? Like any reader aspiring to be a writer, Anthropic's LLMs trained upon works not to race ahead and replicate or supplant them, but to turn a hard corner and create something different. I love how he explains things. We're not racing ahead, we're turning a hard corner. If this training process reasonably required making copies within the LLM or otherwise, those copies were engaged in a transformative use. The first factor favors fair use for the training copies. Now, I'm not going to go over in detail a lot of the other issues, but we do have a couple of issues to look like, and one of them is the conversion from print to digital. Because if you remember, that was part of the 5 questions that he asked them. Top of page 15, all agree on the facts of the format change. Anthropic destructively scanned the print copies to create the digital ones. They had to rip it apart, rip the spine off, take the pages apart individually, feed them through the scanners, and that destroyed the book. The parties disagree about the legal consequences of the format change. Was scanning the print copies to create digital replacements transformative? Here, for reasons narrower than Anthropic offers, the mere format change was a fair use. Here, every purchased print copy was copied in order to save storage space and enable searchability as a digital copy. The print original was destroyed. One replaced the other. And there is no evidence that the new digital copy was shown, shared, or sold outside the company. This use was even more clearly transformative than those in Texaco, Google, and Sony Betamax, where the number of copies went up by at least one, and of course, more transformative than those uses rejected in Napster, where the number went up by millions of copies shared for free with others. And this is like what I was saying going back to the whole format thing. You know, you had your records and you wanted to copy them over to cassette tape so you could listen to them on your portable tape player. They hit the ceiling about that, and the court said, no, they can do that as long as the copies are kept personal. You leave your LP on the shelf, you take your cassette around with you, and you just listen to it yourself. You don't make copies for your friends, and you don't give the LP to someone else or take it back to the record store and sell it as a used LP or whatever. As long as it all stays with you for your own use. Perfectly allowed. This next one is important too. Yes, Anthropic is a commercial outlet. And we've been seeing the Neo-Luddites over on X and everywhere else complaining about, well, they're commercial, so fair use doesn't apply. Listen to Alsup. This is the man who knows. This order takes for granted that Anthropic in fact benefited from the print-to-digital format change, or it would not have gone to all the trouble. But the crux of the first fair use factors concerned for commercial use is in protecting the copyright owners and their entitlements to exploit their copyright as they see fit or not. That the accused is a commercial entity is indicative, not dispositive. So the claims they're all making on social media is that it's dispositive. Dispositive means you draw a legal conclusion from it. It's commercial, therefore not fair use. That's what they want to say. It's merely indicative. And indicative just means you're just conveying information about what was going on, and that can help you in your analysis, but it's not dispositive in and of itself. Yes, authors also might have wished to charge Anthropic more for digital than for print copies, and this order takes for granted that authors could have succeeded if Anthropic had been barred from the format change. But the Constitution's language in Clause 8 nowhere suggests that the copyright owner's limited exclusive right should include a right to divide markets or a concomitant right to charge different purchasers different prices for the same book, merely say to increase or to maximize gain. Remember, the Constitution says this. It's not about enriching publishers, it's to promote the progress of science and useful art. So the Constitution doesn't say it, nor does the Copyright Act itself. As a result, Anthropic's format change from print library copies to digital library copies was transformative under Fair Use Factor 1. Now I'm skipping over a lot of the analysis and going to the top of page 24, but this is the part where we're talking about where they got all these pirated copies of the books. And they're saying, oh, well, you see, they pirated it. And as I pointed out, that means this is no longer an AI case, it's just a copyright piracy case. Like we've seen thousands of others. It has nothing to do with the AI part of it. But what we see from Judge Alsup over and over is he makes a big deal out of the fact that this wasn't just for LLM training. He at least heavily implies that if these pirated copies had been used solely for LLM training and were not to be used for anything else and could not be accessed for anything else, then it would be a different story. But instead, he says, in sum, the first factor points against fair use for the central library copies made from pirated sources, and no damages from pirating copies could be undone by later paying for copies of the same works. That's factor 1. Factor 2 is the nature of the copyrighted work. Here, Anthropic accepts that all of users' books, all published, whether nonfiction or fiction, contained expressive elements. This order accepts authors' view of the evidence that their works were chosen for their expressive qualities in building a central library and then in training specific LLMs. The main function of the second factor is to help assess the other factors, to reveal differences between the nature of the works at issue and the nature of their secondary use above, and to reveal any relation between the amount and substantiality of each work taken and the secondary use next. So for that reason, he says, the second factor points against fair use for all copies alike. Because they're all expressive works, they're all works of fiction instead of instruction manuals or whatever. Number 3, the amount and substantiality of the portion used. Here in the middle of page 25 is the important part. I've made this point over and over and over again. What matters is not so much the amount and substantiality of the portion used in making a copy, but rather the amount and substantiality of what is thereby made accessible to a public for which it may serve as a competing substitute. Couldn't have said it better myself. Or, well, I might have said it better myself. You be the judge of that. But here, once again, there is no allegation of any traceable connection between the Claude service's outputs and author's works. Top of the next page. When a productive use is made possible only by borrowing from a specific work, fair use climbs towards its zenith. When a productive use is possible without that borrowing, fair use falls to its nadir. All agree Anthropic needed billions of words to train any given LLM. If using only books, Anthropic would have needed millions of books per model. Authors contend that because Anthropic showed it could use much smaller sets of books, surely it could have used no books at all, or at least not their books. Why did it have to be ours? Couldn't you just have trained on other people's? You're smart enough to know why that's dumb, aren't you? Yeah, so is William Alsup. But authors forget that reasonably necessary does not mean strictly necessary. Authors do not contest that the volume of text required to train an LLM is monumental. Because using so many works was reasonably necessary, using any one work for actually training LLMs was about as reasonable as the next. For another thing, no output to the public was even alleged to be infringing. So yes, authors' works were chosen as the strongest examples of writing. But the compelling benefits of training the LLMs on strong examples were not offset by revelations to the public of any portion of the works themselves. What was copied was therefore especially reasonable and compelling. The third factor thus favors fair use for the training copies. And at the top of page 27 he finds, the third fair use factor favors fair use for the purchased library copies converted from print to digital. As for the pirated library copies, its objective conduct was to seek all the books in the world, this is important, and then retain them even after deciding it would not make further copies from them for training, indicating there were other further uses. So either they weren't going to train on those books anymore, or they had those cleaned up copies that they'd use for further training, but those originals that they downloaded, yeah, we're not going to use those for LLM training anymore, but we're going to keep them around. We might do other things with them. Alsup's like, no, that don't fly. The third factor points against fair use for the pirated library copies. And the final factor, the effect of the use upon the market for or value of the copyrighted works, top of page 28, the copies used to train specific LLMs did not and will not displace demand for copies of authors' works, or not in the way that counts under the Copyright Act. Authors concede that training LLMs did not result in any exact copies or even infringing knockoffs of their works being provided to the public. If that were not so, this would be a different case. Authors remain free to bring that case in the future should such facts develop. Instead, authors contend generically that training LLMs will result in an explosion of works competing with their works. This order assumes that is so. But authors' complaint is no different than it would be if they complained that training school children to write well would result in an explosion of competing works. This is not the kind of competitive or creative displacement that concerns the Copyright Act. The Act seeks to advance original works of authorship, not to protect authors against competition. Oh, they're going to use it to create works that compete with us and will make less money. Boo fucking who? Copyright is not there to protect you from that. Authors next contend that training LLMs displaced or will an emerging market for licensing their works for the narrow purpose of training LLMs. This order must assume authors are correct. A market could develop. Even so, such a market for that use is not one the Copyright Act entitles authors to exploit. None of the cases cited by authors requires a different result. The fourth factor thus favors fair use for the training copies. As for the format change down here at the bottom of page 29, that factor is considered neutral for the purchased library copies converted from print to digital. Doesn't have anything to do with it one way or the other. As for the pirated copies, not every person who merely intends to make a fair use of a work is thereby entitled to a full copy in the meantime, nor even to steal a copy so that achieving this fair use is especially simple or cost-effective. Here, the copies employed in training LLMs were one thing, but the copies acquired to assemble a convenient, general-purpose library of works for various uses for which the company might have of them, if any, was a different use altogether. So again, he's implying that if it were just for that transformative use of training an LLM, things might be different. But Anthropic screwed up on that one, and therefore the fourth factor points against fair use for the pirated library copies. And as overall conclusion, we're almost done. The copies used to train specific LLMs were justified as a fair use. Every factor but the nature of the copyrighted work favors this result. The technology at issue was among the most transformative many of us will see in our lifetimes. And this is from a guy who's seen a lot. The copies used to convert purchased print library copies into digital library copies were justified too, though for a different fair use. The first factor strongly favors this result, and the third favors it too. The fourth is neutral. Only the second slightly disfavors it. The downloaded pirated copies used to build a central library were not justified by a fair use. Every factor points against fair use. Anthropic employees said copies of works, pirated ones too, would be retained forever for general purpose even after Anthropic determined they would never be used for training LLMs. A separate justification was required for each use. None is even offered here except for Anthropic's pocketbook and convenience. So for each thing you're going to use it for, you need to justify it. If they had only used it for training LLMs, they could have justified it. That's basically what he's saying. But they need to justify all of it, and they couldn't. That's why they lose this point. And as for any copies made from central library copies but not used for training, this order does not grant summary judgment for Anthropic. And by the way, keep in mind that's all it's doing. It's denying summary judgment. A lot of people on the socials are saying, he found that Anthropic pirated copies, that was illegal. No. He's just denying them summary judgment on that. They still got to litigate that. On this record in this posture, the central library copies were retained even when no longer serving as sources for training copies. Hundreds of engineers could access them to make copies for other uses, and engineers did make other copies. Anthropic has dodged discovery on these points. Oh, naughty Anthropic. Judges don't like it when you dodge discovery. We cannot determine the right answer concerning such copies because the record is too poorly developed as to them. Anthropic is not entitled to an order blessing all copying that Anthropic has ever made after obtaining the data to use its words. And now the conclusion. About time. My voice is about to go, as you can hear. I've been yammering for half an hour, but there's going to be a lot of edits. I had to do a lot of retakes. With respect to the training copies and the print to digital converted copies, this order has drawn all ambiguities and inferences in favor of the opposing side, namely authors. With respect to the pirated copies, this order has also accepted the author's version of the facts. Authors did not move for summary judgment, but if they had, then we would have been obligated to accept all reasonable views given the evidence in defendant's favor instead. This order grants summary judgment for Anthropic that the training use was a fair use, and it grants that the print to digital format change was a fair use for a different reason. But it denies summary judgment for Anthropic that the pirated library copies must be treated as training copies. We will have a trial on the pirated copies used to create Anthropic's central library and the resulting damages, actual or statutory, including for willfulness. That Anthropic later bought a copy of a book it earlier stole off the internet will not absolve it of liability for the theft, but it may affect the extent of statutory damages. Nothing is foreclosed as to any other copies flowing from library copies for uses other than for training LLMs. It is so ordered. June 23rd, 2025, Judge William Alsup. Excellent decision, I think. Not necessarily a win for Anthropic, because they still got a case of piracy. And that was because they used all of those things for non-training purposes, and they kept the copies even after they said they were done using them for training. But for AI, and for AI training, for the things we care about, for fair use, this is a 100% win. AI training is absolutely 100% transformative, and if it's not, then nothing is. And just listen to the words of the judge. A very transformative use, highly transformative, exceedingly transformative, quintessentially transformative, spectacularly so, and among the most transformative many of us will see in our lifetimes. So fucking there. AI training is absolutely transformative, so we'll keep an eye on this case, but as far as I can see, the AI part is over, done and dusted. This is no longer an AI case in my opinion. It's just a piracy case. The AI part is over and done. And we'll see what effects this has. This is just the district judge for the Northern District of California, so it's not precedent or anything, but other judges might take judicial notice, and this was already submitted by defendants over at Cadre v. Meta, including a copy of Judge Alsup's decision here, saying, see, this other guy says it's transformative. So we'll see what judicial notice Vince Chabria gives it. And of course, we'll continue following the others too, but this is a great ruling. This is exactly what we need. We might need to go a little further. We still need some fact-based decisions on whether LLM training results in compressed copies of books in the models or not, because it doesn't. Because that's an important point, because it doesn't matter for things like Claude. But imagine Llama or other open source models where you can download them on your computer. If they could get those declared to be compressed copies, then they might be able to consider all of those things piracy, and they would kill open source AI. And we need open source AI more than anything else. That's what will not only propel us through the future, but keep us free as well. We absolutely do not need this locked away in corporations like Anthropic. And the way to do that is to let us download the models for our own personal use. My voice is gone. I'll leave it here. Thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.bogosity.tv. Keep me doing all of this. Any sort of donation, one-time donation, or become a supporter and get these videos early and ad-free. Other benefits as well. Thank you so very much for watching. Until next time, stay strong and be free.